We're going to continue with that testimony live in just a couple of minutes. I'm very happy to introduce our special guest today, Francey Hakes, a former federal prosecutor. I apologize, Francey. I'm so focused on the trial. So I'd love to ask your take, your opinion about some of the information that this computer analyst is sharing. Specifically, he's talking about nicknames that Gypsy, the girlfriend, and the defendant in this case, Nicholas Godejohn, had for each other, Skype messages, all of these things that they were exchanging. And we're going to get more details, but what do you make of the fact that they're giving information that basically there was a love relationship between these two via computers?
Well, Ashley, I think what they're trying to do is make sure they can tie these two together inextricably. They're going to make it seem like the two of them were in love and that one would not do anything without the other. And so you've got a conspiracy here, basically. I don't know if there's an actual conspiracy charge, but you've got a conspiracy here, basically, the state alleges, between these two to kill Gypsy's mother, Dee Dee. And so what the state is trying to do is to make sure that they can show the jury that these two lovebirds were absolutely interconnected and in sync in every way, including in killing Dee Dee.
So it is really interesting, some of the nicknames that they had for each other and the things that they said. It does seem to show that. For instance, it was, he testified, they would say, "I love, worship, and adore you" on their signature line when they would sign off from each other, and that they were soulmates. And so it's going to be interesting to see what else they put. And I think, Francey, let's talk about overall in prosecution of cases and defending cases. Obviously, computers can be the best source of evidence. Tell everyone listening, and what do you make of all of the information that can be pulled off of computers? Is there any reason that you would not think that it's accurate and reliable and credible?
No, actually, in fact, I mean, it's a great point. In fact, just the opposite. Computer evidence, cell phone evidence, digital footprint kind of evidence is critical in all these sorts of cases. Frankly, almost every case now has as a critical piece of evidence someone's mobile phone, whether it's location data, were they at the location of the crime at the time of the crime, whether it's connections on social media to people who are relevant to the crime, or in this case, whether it shows a relationship like it does on these posts between the two of them that the state, I'm sure, is going to use to argue that Godejohn would have never killed, or at least that he was the one who did the killing at the behest of Gypsy. So they want to tie the two together desperately.
So we're going to come back after a short break, and we'll look forward to talking about the next point I want to make with my special guest today, and that is Gypsy going to testify, and is Nicholas going to testify? What do you think? We'll come back right after this short break. Francey Hakes, our special guest today, and I have to tell you, you really hit the nail on the head in terms of all of the data being found and testified to on the computer and the phones, actually showing this relationship between the girlfriend, Gypsy, and the defendant in this case, because it's fascinating how much of this is between them and all of the planning and getting on the Greyhound bus to come to Missouri by the defendant and staying at the Days Inn and doing a Walmart search for different things, including bondage and knives. And let me ask you this. Based on the relationship between the two of these individuals, would you expect the defense to call Gypsy as a witness in this case?
Oh, Ashley, that is a great question. I don't know. I think it probably depends on whether or not she's going to be hostile. I think that if she is going to exculpate Godejohn, that is, if she's going to take responsibility for the murder and say he didn't have anything to do with it, then I would guess the defense would call her. But I suspect that she's not going to say that, and so I would be kind of surprised if the defense called her. I would more expect in this case the state to call her.
And what do you think of him actually testifying in his own defense, given the defense has indicated that they are going to argue diminished capacity because he is an autistic person? Would you anticipate that they will have him testify or not?
I don't think so, Ashley. It's always dangerous for the defendant to testify based on whatever statements he might have made or whatever evidence the state might have against him already. And in this case, I think their best bet to prove that kind of diminished capacity defense is not the defendant. It's almost never the defendant, because if a jury gauges whether or not he seems diminished and decide he's not, then his defense is over. They'd rather call doctors paid for by the defense who will say his capacity is diminished.
And it's going to be interesting to see whether or not the court is going to allow the defense to have a medical expert testify for the defense in this case. We don't yet know the court's decision. To me, experts testify all the time. I cannot imagine why the defense would not be allowed to have an expert as to this being an autistic person. What do you think of that? Do you think one should or shouldn't be allowed?
Well, that's a great question, too, Ashley. I mean, I think as a prosecutor, I would have fought it hard and basically said, put your client up or you don't get this defense. But I mean, in a diminished capacity defense, the defense is entitled, I think, to provide a medical expert to explain to the jury why the defendant could not have understood exactly what he was doing. It's not an insanity defense, but it is kind of a baby insanity defense. And so they're going to try to establish through that kind of testimony that diminished capacity. And I think the judge has to let him do it.
And remember, in the police interrogation that we saw, he certainly was forthcoming and gave full, complete answers. So it's going to be interesting to see whether or not he testifies. We are going to go to a break, but please come back for more of this trial. Well, wow is all I can say about these texts that are being read into evidence at this time. Francey Hakes, our former federal prosecutor, joining us. Francey, the first thing I want to ask you is there's so much in these texts we could talk about all day, but let me focus on, at one point he said 3 different times via text, he being the defendant, "It's just your freakouts that scare me, hun." And in one text in response, she even said, "Yeah, basically I agree." So does this mean that he's afraid of her? And if so, is that a valid defense for him?
Well, Ashley, great points. I don't know. This is the weirdest relationship I've ever seen play out via text. It seems more codependent than love. They seem at the same time immature and impossibly old with some of their language and the way that they refer to each other. I think it's interesting to know whether or not Gypsy Blanchard will testify and if she's doing so under an agreement with the state to cooperate in return for her reduced charge. If so, you can expect her to blame him, and that's why these text messages may be important to the defense, is because they will show that she, if they do, that she was the ringleader for this, and he was just following along.
Right. No, I agree. So let me ask you, in terms of trial skills, what we're hearing is basically a monotone reading of texts, just straightforward. How is the jury receiving that? And is there any way it could be done differently?
Yeah, they lost the jury an hour ago. Studies have shown that juries can pay attention for about 20 minutes at a stretch. And when you're talking about the computer forensic guy who did quite a good job early on, when you talk about him reading in a monotone text messages for, what has it been, at least an hour now, they've lost it. Hopefully they have these printed out so the jury can look at them in the jury room. But I think this kind of presentation, unless there's just gold in here I'm not seeing, is a mistake.
Okay, so let's talk about evidence and what we're allowed to do as attorneys and trial attorneys. Is it true that if the prosecution had chosen to, they could have picked certain texts, provided all of them, had them all available so that defense can use what they choose to, but they could have had him read only certain text? Would that be allowable or not?
It is. There's something called the Rule of Completeness, so they're not allowed to just enter some of them into evidence. They would basically have to enter them all, but they don't have to read them all or present them or what we call publish them all to the jury in this form. They don't have to read this like this.
Okay. Now, the other thing, and you already referenced it, as an immaturity of these texts. It's interesting, and I just want to point out, Gypsy at the time of these texts was approximately 23, depending on her date of birth, and he was 26. Go to John, the defendant was. And so what's interesting to me is if I were to read these texts without knowing who had written them or typed them, I would think they were much, much younger, maybe even just a young teenager. But then on the other hand, they really make me blush. Does this give the defense all kinds of evidence to really use when it's their turn?
Well, I think they're going to be able to use these texts, Ashley, to argue that Go to John is immature and has diminished capacity. When you read the relationship between the two of them, it doesn't seem like a normal, healthy relationship. You've got Gypsy going on these, whatever these freakouts are, and then apologizing and asking him to forgive her, and him forgiving her, and all this hun and darling and dear. And it does seem as though she's a little bit more in control than he is, at least in these texts.
And, you know, some of these texts makes me blush, which is sometimes hard to do as a trial attorney doing a lot of horrible crimes in trial. You see everything, you hear everything, but some of these texts certainly are very, can make you blush. Let's just leave it at that. We're going to take a short break, and we'll be right back on Law and Crime. I'm with Francey Hakes as we continue to hear texts being read into the record that were between the defendant in this case and his girlfriend Gypsy. So, Francey, one of the questions I have is let's talk about the possible scenarios and whether or not you think these texts contribute to each of these particular scenarios. First, we could say that these two conspired, and they're both guilty of killing Dee Dee Blanchard. Second, perhaps she did manipulate him, and he did not have the ability to make the decisions or the right decisions because of her manipulation, and he did stab her but has a defense. The third scenario that we've talked about and that I think exists is that what about, did the defendant perhaps control Gypsy, and he did this crime, he killed the mother because of the mother's abuse of Gypsy as a child? So tell me, are those all possible scenarios in your mind in this particular case?
Yeah, Ashley, I think they are all possible scenarios here. I think the defendant is responsible, just like I thought Gypsy was responsible, and I think they're appropriately charged and convicted, at least on Gypsy's part. But with respect to these texts, I think it's interesting because you can actually read them a couple of different ways. It certainly can appear that Gypsy is actually the one controlling Go to John. First, through sympathy, that is the tale of having to sleep outside and go to the bathroom in the bushes and being abused by her mother, but which by all accounts is factual. And then secondly, by going through these times where she's yelling at him and she's angry, and then she'll dangle cheating on him. Would it be okay if I had sex with someone else before I left town? So she has definitely got a bit of manipulation going on here, and I think the defense will be able to at least somewhat successfully convince the jury that he was being manipulated, but that is not a defense to murder.
So could he be found guilty of a lesser included offense if the jury chooses to go that route?
Yeah, well, they certainly could, Ashley, but I don't think so. I think if the jury believes that he's being, even if the jury believes he's being manipulated by her, I still think they'll hold him accountable unless they buy the diminished capacity. The manipulation won't give him a pass, but diminished capacity could.
All right, we're going to go back to live trial now to hear more of the text between the defendant and his girlfriend, Gypsy. Welcome back, everybody. You can see it is late in the day. They are in trial about 4:45, and they are going to be ending for the day. The judge just gave instructions to remind jurors not to talk about the case, not to have any discussions, and they are going to be on recess for the rest of the day. We don't yet know what time court will resume tomorrow, but we will certainly let you know as soon as we know. Now, in the meantime, let's talk about a couple of things. The testimony about all of the texts between the defendant and his girlfriend, Gypsy. We could talk about that all day long because there's so much information. But two things I want to do first. Number one is let's talk about kind of a summary of where we are in this case. In Missouri, sentencing is done by a jury. So if there's a conviction of anything, either the murder 2 charge or a lesser included offense, there will then be a penalty phase and the sentencing will be done by the jury. Now, in Missouri, if the jury cannot reach a unanimous decision, at that time, the judge gets to determine the sentence and pass down the sentence. So that's what we can expect, a penalty phase if in fact there's any kind of conviction, and I can't imagine that there won't be a conviction of at least a lesser included offense, but that's just my opinion. We never know what a jury's going to do, and I certainly don't know what to expect in this case. Now at this time we're going to go back to testimony, and this is from again the computer analyst, and he is discussing the search history that he found on the computer, searches done by the defendant in this case.
On that was perhaps more sophisticated or different than what a typical user would do in your experience? There is a little bit something.
So there are some audio difficulties with that particular clip. So we're going to go to a different clip and hear more about previous testimony in this case.
And so the clock that we blown up there, that's just a blow up of what's underneath.
All right, so we had some more audio difficulties, end of the day. So instead, I'm going to talk again. Francey Hakes, I have a few more minutes with you. Let me make sure. Francey, are you able to hear me?
I can.
Okay, great. So let's talk again about the penalty phase, just to give viewers an overview. First of all, let's start at the beginning. So we know that Gypsy did plead in this deal, and she entered a plea to murder in the second degree, 10 years. Now, from my perspective, my experience in the state of Georgia, 10 years is a pretty good deal for a plea to murder too. What's your perspective?
Yeah, I think you're right, Ashley. I mean, that's not a long time for committing a murder. Every state has different degrees and different penalties for different culpabilities with respect to murder, whether it's a crime of passion, a murder for hire, something that was premeditated, murder of a child, murder of a police officer. But 10 years is not very long when you have conspired with someone else to kill your mother.
And so how much does the jury take that into account when so far the testimony is that she did not stab her mother? John, killed Dee Dee, her mother. And so how much does her plea come into play, or does it at all in terms of him being convicted for this offense?
Yeah, I think that'll obviously be an issue for both sides to discuss and debate and argue to the jury. I think the interesting thing about her sentence in this particular case is I've got to believe the state thought that a jury would be very sympathetic to her factual tale of a lifetime of abuse at her mother's hands. And so I feel like that factored in, and I suspect it'll factor into this trial as well.
All right, so lastly, we're walking through chronologically the different events. So if he is convicted even of a lesser included offense, then there is going to be a penalty phase. In general, as a former federal prosecutor, what type of evidence would you want to present in a penalty phase of a case?
Well, the evidence in aggravation here would include the number of times that she was stabbed. That'll certainly come into evidence in the guilt-innocence phase. But as the judge decides what to sentence in this case, the judge will consider all sorts of factors. Any prior criminal history that the defendant has, the jury definitely won't hear about that. The judge will take that into consideration. So I would be making arguments about any prior criminal history, the premeditated nature of this crime. That is, they discussed it, they planned it, they executed it. It was particularly brutal and cold-blooded, I think, to stab a woman that many times. And so all that will come in for aggravating evidence.
And then on the defense side, they're going to bring in mitigating evidence. Is that right? Is that right? Anything to show that the mitigating circumstances mean that he should receive a lesser sentence?
That's right. Even if a jury doesn't buy their diminished capacity defense, they will still raise it again with the judge. They will talk about how he is less culpable or less responsible for his actions, and therefore his penalty should be lower, that the circumstances of this case would never arise again, and so he's not a danger to the community. All of those arguments will be made by the defense for sentencing.
So now that we've talked through the chronological order of events, we are going to now replay a recap of the opening statements in this particular case.
On Missouri for the trial against a Wisconsin man accused of stabbing his girlfriend's mother 17 times. 28-year-old Nicholas Godejohn and his girlfriend, Gypsy Blanchard, are accused of killing Gypsy's mother, Dee Dee Blanchard, who was discovered in a pool of blood in her bed in 2015. Prosecutors began their opening statements by pointing the finger at Gypsy as the mastermind behind the murder. The state then focused on the defendant, claiming that Godejohn was just as responsible for Dee Dee's death.
Outside of Claudine Blanchard's bedroom door stood the defendant, dressed in all black, wearing blue latex gloves, holding a knife. It was a year prior when the defendant, while speaking with his girlfriend Gypsy, was first introduced to the idea of killing Claudine Blanchard.
The defense fought back, countering the state's narrative by downplaying Godejohn's role in the murder, stating that Nick was just going along with Gypsy's plan.
Gypsy knew there was only one way she was going to be able to spend a life with Nick. There was only one way to get out from under the grasp of her mother, and that was to kill her mother. Nick arrived there at the house. Knife was ready, gloves were ready, tape was ready. He entered that home and saw Gypsy standing there, and Nick went through with Gypsy's plan.
Godejohn's team also introduced the defendant's autism diagnosis, arguing it explains the dynamic of the couple's relationship and Gypsy's power over the defendant.
You're going to hear testimony about Nick's autism. You're probably going to hear from a couple of doctors who are going to tell you Nick is autistic. He has a low IQ. He suffers cognitive disabilities. Nick wasn't able to formulate the necessary mental state to commit murder in the first degree.
Godejohn faces the possibility of life in prison if convicted. For the Law and Crime Network, I'm Aaron Keller.
So you just heard the breaks from the recap from the opening statements. I got excited because it says that they were downplaying the defendant's role, but he actually stabbed the mother. So I'm not sure how that's going to work.